All right, we have a lot to cover. So we will go ahead and kick things off. I am Amelia Vance, president of the new nonprofit, the Public Interest Privacy Center. This webinar is co-sponsored by AASA, the School Superintendents Association, and their Student and Child Privacy Center. So as much as I was sad that I knew one of my days last week was going to be eaten up by our 227 page document from the Federal Trade Commission, I knew that we should absolutely dig in and talk about it with some of the smartest people I know. And thankfully, they all agreed to participate. So our panelists today are Ariel Fox-Johnson, Sara, Kloek, and Cobun's Zweifel-Keegan. I will let each of them go ahead and introduce themselves. So Sara, let's start with you.
Thanks, Amelia. Hi, everyone. My name is Sara Kloek. I'm the VP of Education and Children's Policy at the Software and Information Industry Association. Spend a lot of time working on COPPA and FERPA, including when I was working at the U.S. Department of Education back in 2016 and 2017. So I've been waiting on this COPPA rule for some time.
Excellent. Cobun.
Hi. Yeah, thanks so much for having me, Amelia. I'm Cobun. I work as IAPP's managing director for our DC office, and I'm a privacy lawyer. I've been interested and engaged on kids and teen privacy for a long time, but I end up being a bit of a generalist in this role, so I'm excited we get to chat and go deep on COPPA.
Absolutely. And last but certainly not least, Ariel Fox-Johnson.
Thanks, Amelia. I'm Ariel Fox-Johnson. I am the founder of Digital Smarts Law and Policy, and I'm a senior advisor on data privacy to Common Sense Media. Like these folks, have worked on COPPA for over a decade. Common Sense has filed numerous COPPA comments, advised companies on COPPA compliance, and filed complaints to the FTC about other COPPA concerns. So glad to see this rule.
Yeah, I think combined, we might actually have 35, 40, 45 years of COPPA on here. I think that's actually a little low. So we're going to share as much as we can, but I also see in our attendees some of the most brilliant COPPA experts that we know as well. Feel free to throw things in chat or Q&A. Would love to have additional thoughts. We also want to be responsive to all of you. So while we have a packed agenda of what to talk about, we are very interested in all of your questions. So if you can use the Q&A, which should be at the bottom of your screen, to ask those questions, that would be fantastic. All right, let's kick things off. We're here to discuss the FTC's new COPPA rule. Why do we care? For the probably 5 people on this webinar who don't know what we're talking about, the Children's Online Privacy Protection Act was passed, I'm going to mess this up, 1998. And it was pretty short if you look at the statute itself. The statute was instigated by the FTC. The FTC said, we don't have sufficient protections for kids. We need to do more, put out a report, pushed Congress forward. They went ahead and passed the COPPA statute and gave the FTC extensive authority to flesh it out and create the COPPA rule, sometimes just called COPPA because that's what everyone's following. So the FTC put out their first COPPA rule in 1999. And then the most recent iteration before last week was in 2013. Not to say that the rule is the only thing we have when it comes to interpreting COPPA. We have some amazing FAQs, guidance, etc. from the FTC. you haven't looked at it, you definitely should, particularly if you're a company. And we care in many ways because the fines are potentially enough to bankrupt a company because we care about kids and we want to make sure that their information is protected. And we want to make sure that parents have sufficient control and insight and transparency into what is happening with their children online. It's important in looking at COPPA to realize that there are some limitations here. First and foremost, COPPA only protects information that is collected from kids online, which means that there's information about a kid online. If someone posts a photo, your grandmother writes your bio on a Facebook page, that information is not protected. So it is just what the child themselves enters in that is protected. It's a little more nuanced than that, but I'll leave it at that. So we've had several proposals, which we'll talk at the end of the webinar about, to amend COPPA and expand it. But this new rule is really the first substantive update, certainly this decade, but since that 2013 process went through. So we have a new rule. Sara, how did this happen? What was the process here of creating the new COPPA rule?
Sure. Well, I think any COPPA rulemaking, any rulemaking in general is always a little bit of a long process. It's not cut and dry. This particular rulemaking officially started in 2019, or this process officially started in 2019 when the Federal Trade Commission announced a rule review. But it started a couple years informally before that when the FTC started holding workshops. They first held a workshop in 2017 on COPPA and FERPA and the intersection and how those laws are thought about in the school context and outside of the school context. They held another workshop on COPPA in 2018, announced the rule review process in 2019, and then in March 2020, things changed a bit. So there was a delay in what a normal process would look like. They began in earnest with a rule review, and they issued proposed regulations in 2024. Am I getting my days right? And
before Christmas 2023, and then posted in 2024.
I'm like, I know it was due in March, but I think there was a 90-day period, so I couldn't remember if it was like the beginning of January or end of December. And then the final rule came out. So it's been complicated, but the last rulemaking, there was a proposed rule and then a supplemental proposed rule, 2011, 2012. So I think there's not a straight path to any final rule, but what we have is what came out. And I did see a question in the comments or in the Q&A about how the regulatory freeze executive order may apply to the COPPA rule. We were all doing the math on that before, so we are watching and figuring it out. Yeah.
Obviously, we are all very certain. And I am also going to try and answer things in chat as I can in between everything. So let's quickly start with significant issues that didn't make it into the final rule, because there were some major surprises, particularly for me, who focuses quite a bit on student privacy, as well as child privacy broadly. So back in 2017, the Department of Education and FTC put on a workshop about the intersection of COPPA and the federal student privacy law, FERPA. That was 8 years ago. We have not seen anything come out of that workshop. And so many of us were very happy when comments were requested in 2019 that asked about education. And then again, very happy with the NPRM last year, which had some pretty significant safeguards and clarifications as to how schools fit in COPPA. Because COPPA is based on the idea that parents are consenting to children's personal information being collected from them. But of course, in today's classrooms, you have tech being used all the time for attendance, for, art, for, the equivalent of the textbook. I'm sure Sara can give a million more examples. There's so much that it is used for, and a ton of ways that it's used, not just as something that has a paper replacement that would be really easy, but in ways that further learning in many ways. I personally wish Duolingo had been around in my foreign language class. What this clarification would have done is spelled out something. The only guidance that we have had from the FTC on when schools can consent to the use of tech instead of parents is from the preface to the 1999 COPPA Rule that was put out. And everything else that we've seen has been strictly in the COPPA FAQs. So we know that schools can consent as long as they're consenting to tech being used for a solely educational purpose. We know that there are some requirements. Companies can't compel schools to provide this consent or pass the burden of it onto schools, but there have been a ton of questions. Does there need to be a contract? What needs to be in that contract? Do permission slips need to go back? What is the level of transparency that is required? Because COPPA has a lot of requirements for transparency and access for parents. Does that go to the school? Does it also go to the parent? And so the NPRM had what I think was some really solid language that said, here is how this works. Here is what has to be in a contract between a company and a school, including a specific authorized individual who has the ability to bind a school to a contract. And here are the limitations under which data can be shared in education. Much to our surprise, while the education section was a significant part of the notice of proposed rulemaking last year, the education part, I think, was a page and a half here. And the FTC said that they had decided to not include any of the education sections, noting perhaps a little flimsily that the reason was to avoid making amendments that could conflict with potential amendments to the Department of Education's FERPA regulations. As many of us know, the Department of Ed has been saying that they will release FERPA updates since 2018, when they were legally obligated to put them forward by Department of Ed's Office of Inspector General. And 7 years. So I know it was extremely discouraging to me on that, particularly when you think about the fact that the FTC is in charge of companies, not the Department of Education. This really is theirs to regulate, as we've seen with some amazing settlements against ed tech companies over the past several years. Who else maybe wants to weigh in on this? Sara, I know you have thoughts. First of all, that DOE is the Department of Energy and not the Department of Education, and the FTC should know its acronyms better.
Yeah, there was that thing that I noticed in the whole rulemaking. The official acronym for the Department of Education is ED, ed, not DOE, but they use DOE throughout. I also wanted to mention that the FTC does have a policy statement that they issued in 2022. It's called the Policy Statement of the Federal Trade Commission on Education Technology and the Children's Online Privacy Protection Act. I can throw that in the chat. It's also fairly easy to find. But I think that does provide some guidance, but many of the folks in the field have been interested in having the Federal Trade Commission clarify what they said that they were going to clarify in 1999. And it's been COPPA is over the drinking age now. So I think we are ready for some clarifications there. But yeah, I think it's an ongoing, it's ongoing.
Ariel, is there anything you wanted to add on that? Or we can move on to push notifications.
Yeah, I was just gonna say COPPA is old enough, I think, to rent a car now, but happy to move on to push notifications.
Perfect. The other big significant change from the NPRM that the FTC decided to not include is related to push notifications. So Ariel, can you please share what they had originally proposed, what they said was not included, and really your thoughts on sort of their explanation and it not being included in this final rule?
Yeah. So as many of the COPPA enthusiasts on this call know, there are exceptions to when you have to get verifiable parental consent. And one of those exceptions is the sort of multi-contact exception, using a child's personal information to respond to more than one request that they make. The FTC in 2024 proposed clarifying that exception, which is at section 312.5 C4, would not apply if the purpose was to encourage or prompt use of a website or online service. So the FTC, like many other regulators, was concerned about prompts for excessive engagement among individuals. It also, came up when they were considering whether they wanted to further clarify what internal uses, which is another exception to parental consent, operators could make of children's personal information. Basically, the FTC decided that operators do not need to get parental consent if they're going to use. They declined to explicitly state that parental consent is required when you are using information in this way. They did not put it in as a prohibition. They did say that in the multi-contact exception, that you can only be using children's personal information to respond to a direct request. So if company, and this is sort of in a footnote in the multi-100-page NPRM or final rule, if you're using children's information to contact them multiple times and it's not in response to a direct request, which maybe certain engagement pushes are not, then the FTC could go after you for violating COPPA. There are reasons for doing this. They had groups who filed on both sides. Common Sense, who I filed comments on behalf of, was very supportive of them adding in this restriction because the view is that engagement techniques using children's personal information are really problematic, and that one of the original purposes of COPPA was to kind of give parents control over how marketers, on the one hand, and also kind of strangers on the other, contacted children online. And these pushes for engagement or pushes for other things like in-app purchases seem in line with that marketing view. So that was one view. And on the other hand, there are many folks who flagged that there can be positive uses of push notifications and other reasons to get kids to use a website or use an online service. So the FTC considered both, and in this instance, declined to make that change. And I've, read many view this as the FTC kind of staying in its lane, not adopting age-appropriate design code principles that may be elsewhere. Though worth noting that the UK privacy regulator did consider this use of children's personal information to be something they could regulate in the design code. But that was another thing that they had proposed that they kind of pulled back on in the final rules.
I thought that discussion in the final rule was really interesting. Just you can see the diversity of thought among the commenters, and you can pretty easily see both sides. Like if you are contacting a kid that says buy more Smurf berries, buy more Smurf berries, versus a push notification that says don't forget your homework, here's what's due today. Like those are two different types of content, and figuring out how to regulate that is really hard. If it's a content-based regulation, that's a very difficult thing that policymakers we hear are considering elsewhere, or like in the UK and elsewhere in the US, that folks are continuing to debate.
I was personally fascinated by the number of times in areas where the commission said that maybe they wouldn't go quite as far. They were going to deal with these issues. They cited many of the comments that then cited the First Amendment and included that not just in the footnotes, but more broadly. I think it's a interesting continuation of the number of cases that are happening right now. I've lost counts. I think there's definitely more than a dozen. One of them, or at least one of the relevant ones, going up before the Supreme Court around age verification this year. The First Amendment is having its day on the internet in a way that it really hasn't since a lot of the 90s cases. And so for the FTC to mention that quite as often, certainly a reflection of the comments they got, but also interesting that the FTC thought it was important enough to include in the text itself. So with that, talking about what wasn't included, Ariel, let's go ahead and have you talk about what the FTC changed regarding parental consent. And I know this is a big bucket, so maybe focusing on, the separate consent that they ended up implementing here.
Sure. And I'm going to talk about sort of what was included, and I see a question about something that wasn't included too in this separate consent area. So arguably, or maybe not arguably, one of the biggest things that this rulemaking does is create a requirement to get separate consent before operators disclose or share or sell children's personal information to third parties, unless it's for sort of an integral purpose. And, parents have to be able to consent to the company's or the, operators' use of the collection use of the information without having to consent to disclosure to third parties for non-integral purposes. So I think that is debatably something that could have been read into the rule before, or that people did read into parts of the rule before, but now it's very clear. And the FTC said that if you're a website and you have a bunch of sort of third-party trackers on your website, there needs to be separate consent to disclose information to those third parties, again, unless they're doing integral things. One thing that was not included is that some folks wanted the FTC to specify, like, okay, what's integral and what's not. Are there certain things that can't be? For example, Common Sense wanted language about how use of children's data for AI training purposes or for behavioral ads, would never be integral. The FTC declined to put that into the rule language, though they did say in the NPRM that disclosure of a child's personal information to third parties for monetary or other consideration for ads or to train or otherwise develop artificial intelligence technology are not integral to the website or online service and would require consent pursuant to the proposed amendment. So I think it's sort of interesting when they sort of decline to put something in the body of the rule, but they still say it in the text. So that I think will be a big shift, getting that separate consent, what it will look like. I think the FTC gave flexibility on that, but others might have views on the flexibility or lack thereof.
I think
Yeah.
what you said about how it's not in the text of the rule, but it's or the actual rule, but it's in the text of the rule. I think is really important for folks that are working in compliance. Folks are going to have to read through the whole 225 pages to like make sure as they're building out their programs of what they need to comply with. You can't just reference the actual rule text here. Just if you're looking for additional guidance, there might be more stuff in there. And we all need another 200 so pages to look at, but you have an extra 60 days at least.
There you go. There's something there. I think also worth flagging on the algorithm side, we'll talk about in a minute about some of the interesting data retention related arguments between commissioners in statements. But at the time, Chair Khan, her statement specifically talked about the importance of clarifying that companies cannot retain children's data indefinitely, citing that companies kept saying that they needed to keep the information in order to train their algorithms. So Khan said, for example, FTC's enforcement experience has already shown firms citing machine learning as justification for indefinite retention, and the commission has made clear that these AI claims do not override legal bans on indefinite retention of data. Ariel, can you, it's sort of related to that. I don't know that everyone understands what a big deal it is that parents have to consent sort of in some ways multiple times to different uses. Can you talk a little bit about the current process, just really quickly, and sort of what companies might have to do now?
Yeah, I mean, the current process, as I've seen it both in places where, I've been advising or in places where I am the parent consumer, is generally one consent. And it is kind of a take it or leave it, though again, I don't know that was always depending that could be appropriate or that could not be appropriate depending on what you're offering. I think now there has to be sort of clear explanation about what you're planning to do with the personal information. And there has to be a distinction between, me as a parent consumer allowing the first party operator on which I want my child to be to collect and use information. And then for any non-integral sharing, there has to be a separate consent that I've given that is informed, and I have to be told in the notice that when they're getting that consent, both information about the third parties and also that I don't have to consent to this third party sharing, which, given how confused we generally hear parents and consumers are, I sometimes think of parents as the most confused consumers because they're a couple steps removed sometimes from what's going on, and have limited time, but they you know, being just told that could be really helpful to be like, okay, I don't need to agree to this. So I think that's very different.
I will say, as particularly because I just started teaching my annual EU data protection seminar at William and Mary, I was fascinated that the FTC included what almost felt very GDPR like, which was, you know, the key question is whether a parent's consent to disclosures is freely given, informed, specific, and unambiguously expressed through an affirmative action distinct from the parent's consent. And to be clear, consent flows that mislead, manipulate, or coerce parents, including choice architectures that deceive parents about the effect of a consent or trick parents into providing their consent, will not suffice. I mean, obviously, we've seen this with recent US laws as well, but especially that freely given part, it just felt like it was picked up from GDPR. So, really interesting aspects there. Cobun, any thoughts on that?
Yeah, that's a really good call out, actually. I think this is the first time we're seeing that kind of language embraced by the FTC, which is always taken seriously. It's the commitment to affirmative express consent in certain situations, including COPPA. But the reality is that every state law, all the 19 comprehensive state laws use that language. And so although it originates in GDPR, it has swiftly become the standard of consent in the US, but like not necessarily operationally. I think companies are still catching up, and we're starting to see regulators look a little closely at maybe whether we're getting enough of all of those adjectives in play when we're getting consent. So it is interesting that it's included there. Um, I think we should also probably talk about this, uh, the need to list third parties in these parental disclosures, right? I know that's a big thing that stood out for me because and that is also sort of consistent with the general direction of policy. We're starting to see more prescriptive requirements to say not just the categories of third parties that you're sharing data with, but the exact entity names. Oregon's state law, state comprehensive law includes a requirement to do that. If the consumer requests, you have to give them the list. So it doesn't have to be in your public privacy notice. But this does. This is both in your public privacy notice and in the parental disclosure. You have to say the names of the third parties that this is going to, which is a slight tweak from the NPRM. I think they picked the strongest possible that they had proposed there. And it sounds like a small thing, but operationally, it's always a major hurdle for companies, especially as there are a lot of third parties in various contexts. And so that will be a whole process to get in play for sure.
Absolutely. Ariel, why do you think the requirement to list third parties here is valuable? And I should say it's COPPA is confusing because it includes two different types of notices. If you do not do both types, you will be fined. That's a lot of the early COPPA cases. So you have a direct notice to parents, and then you have to have an online notice. In this case, in the direct notice, you have to list either the name or the category of third party. And in the online notice, you have to do both. So, Ariel, why do you think they put this into place? Why do you think it's important?
Yeah, I think so. One of the things that groups like Common Sense wanted was more inclusion of categories. And as Cobun mentioned, this requirement to list information about third parties is something we see in a lot of state laws. And for example, in California, it asks for categories. And one reason that categories can be really helpful for consumers is because there's so many different entities operating online that names can be very meaningful or not meaningful at all. And sometimes categories, especially if described appropriately, can be more meaningful to parents. Categories can also, you could game this out a variety of different ways and also have categories be not helpful. But aside from companies everyone has heard of before, categories I think can be in some ways more helpful. I do think this is another example where the FTC was trying to be flexible with operators and also understanding that you don't want direct notices to be too long. So you have a choice in your direct notice, and hopefully, operators will choose whichever listing is sort of most effective for parents. And then in the online notice, you have a longer listing for both.
Yeah, and I think it's meaningful that it's a specific categories, right? They're saying, let's be like, I think that language is trying to avoid this issue of like really broad category names.
Marketers.
Right.
Yeah,
Or
I think
for whatever, like operational services or something, like you can have these really broad things that aren't very helpful to the consumer.
absolutely. I think my favorite part of this, where the FTC was like, you think this will make us notice too long? Use how you design your website. Have drop downs. They're reminding companies there are designed ways to make this a little better for consumers. So that was a fun little call out. So Sarah, Cobun sort of referenced this, but why is this hard to do? What do you think might be some unintended consequences from requiring all the third parties to be listed? And I know there was a little bit to hear in Commissioner Ferguson's note as well.
Yeah, I think it's Cobun said operationally could be difficult, and you referenced, Amelia, that the FTC said use your design techniques, but I always think about all of these notices need to be accessible to all parents, so figuring out how to make it accessible to all parents is important, and making the user experience good. And
Just really quickly, when you say accessible, can you remind us sort of the breadth of what that means?
Yeah, I'm talking about, we want to make sure that it meets your users where they are, whether they're using screen readers, whether they're using other sort of navigational techniques. That's a best practice for some and a requirement for others. There are some requirements for companies serving governments, making sure that your products are accessible according to WCAG, depending on the day, 2.1, 2.0. States have requirements. That's a whole nother webinar series, Amelia. But also making sure that parents can understand it. And I think that's one of the issues that this brings is this going to cause consent fatigue when parents are clicking through? Are they going to be interested in clicking? Are they going to drop off? We just don't know. That's an argument that that is frequently mentioned. And I think that some folks really do want this process and others may not. So I think I would like to see a study on parental consent techniques and if there's drop off, but I don't know if anyone is willing to do that yet. But I really want to know. And also I think I guess now Chair Ferguson did bring up in his statement that there may be some competition concerns here, and we also don't need to talk about antitrust law in this.
Absolutely. And I will make your day, Sarah, by pointing out the great Future Privacy Forum report that I got to work on, which has, let me see, on page 6, a lovely infographic about the friction points of verifiable parental consent, and sort of when you duplicate that by having to send out a new consent maybe each time a third party changes. I think Ferguson sort of like raised that as a particular friction point. At the same time, though, some of the suggestions that he listed as reasons why you should notify parents are things that in the primary sort of write-up of the rule, they said maybe you don't need to notify parents about this. So I think there may end up being some confusion about when something is big enough to require a new consent, at least for a little while. So let me see. I got lost now. Among other things, um, data retention policies have to now be included in the notices to parents. Cobun, can you mention really quick sort of what this is? And then Sara, would love to hear from you why this is controversial. I mean, the FTC continuously pointed out how many companies had filed comments on the issue.
I mean, I think it's a great example of the FTC's continued emphasis on data minimization generally. And I think there has been a long-standing kind of push towards having retention policies. I think what's particularly new here is saying that they have to be public, that this has to be something that's shared, which isn't usually, if you have a dedicated retention policy, it's not often posted on people's websites. I don't know. I think that's not a usual practice. Hopefully companies, like, you will often mention some retention parameters, but hopefully you have kind of more specific retention policies internally. And it seems like this is now a push to make those public, either the specific retention policies for children or a general one that meets those requirements, just like the security requirement, right? I think that's the contour of it.
Absolutely. Now has to be inserted into those notices. So I'm not sure if it's both of them. It might only be one. Double check. Sara, why is this potentially controversial?
I think that it is it's a lot of information to put out there. And I think that data retention may depend on the type of data that you have and what you store it. Also, in the education context, there may be specific contractual agreements that require you to keep data for a certain amount of time in one state versus a different amount of time in another state. So your data retention policies may differ by state or by district or by school. So figuring out how to have those on your website so you're clear and not making deceptive statements will be important. But I think it's going to require a review of like what your agreements say, if you have an agreement with a school, what your agreements already say with parents, and also what consumers expect. If this is a non-specific example, but if you have a blog and you are under the age of 13, do you want that blog to be there forever? Do you want that blog to be deleted when you turn 15? It depends. So I think there's some questions that remain there.
You just reminded me of one of my favorite parts. You need to find it somewhere in here of Ferguson that said, you know, many adults might be surprised about like their online diaries and, you know, other stuff suddenly disappearing. And my first thought was, I don't think anyone of us would have a problem with that.
Maybe Chair Ferguson has a dormant live journal somewhere on the internet. I'm just kidding. I'll make that very clear. I'm just kidding.
So Ferguson was fighting a little bit with the majority on this point. So noted in his concurring statement that if, you know, indefinite is not meant to be taken literally, it's unclear how this requirement is any different than the existing requirement to keep information no longer than necessary to fulfill the purpose for which it's collected. It's a fair critique because companies have been saying they will retain data only as long as needed to fulfill business purposes. And many companies at least haven't been clear on what their data retention proposals were. And so requiring that there be data retention proposals may actually solve this. But when you look at the other commissioner statements I mentioned, former Chair Khan's note on AI. You also had concurring statements from Commissioners Bedoya and Slaughter saying that, a wave of companies now claim that it is reasonably necessary to keep that data forever. Today, we clarify that's not reasonable. And I think in particular pointed out like the Edmodo settlement is an example of a company that had no plan to ever delete their data, at least allegedly. So really interesting that ended up being maybe the biggest point of friction, sort of felt like, in that concurring statement from Ferguson. For those who don't know, by the way, the reason we're focusing so much on Commissioner Ferguson is the new chair of the FTC and will be setting a great deal of its direction moving forward. So we're all watching for, lots and lots of signals. One significant issue that always comes up when stakeholders discuss COPPA is what is permitted in terms of advertising. So, Ariel, can you please share what the final rule said about contextual advertising and behavioral advertising?
Yeah, and I think so there's the what it said with respect to disclosures to third parties for purposes of advertising, which is a big clarification or maybe a big shift. But with respect to companies, operators' own use of personal information, in some ways, I think they declined to make changes to how they treat contextual and behavioral advertising. So for contextual advertising, it is permitted as something operators can do under the internal operations exception. You can use persistent IDs for contextual advertising, and that is under an exception to parental consent. And the FTC declined to change that or say that you couldn't do that anymore. The FTC also declined to sort of categorically ban targeted ads or state that the use of children's personal information for behavioral ads is more than is reasonably necessary for them to participate in an activity, which is something that some commentators, many consumer groups, had urged them to do. There had been some questions about if it was a flat prohibition, if you're not allowed to collect more than you reasonably need for the child to participate in the game or the activity, then you can't collect it, even if a parent is consenting to it, arguably. But the FTC in the final rule said that they were not attempting to categorically prohibit behavioral advertising to children where the parent has provided consent. And the amended rule does not prohibit operators from collecting personal information to engage in targeted advertisement so long as they have gotten consent from the parent, and this consent is not optional and freely given as described before. So this is a little interesting for people who watch behavioral ads in the kids space generally, because there are states that have stronger rules that flat out ban behavioral ads to children or to minors, like Maryland. And in the federal COPPA proposal, which had bipartisan support and got through the Senate this summer, there were flat out bans. But this rule doesn't do that.
One thing I'm really curious about with Chair Ferguson, so many of you may have missed, there was an FTC settlement related to COPPA that came down on the 17th because we didn't have enough to do last week. And his statement concurring in part and dissenting in part was really interesting to me, because he noted that in regards to something that was a little, not quite a dark pattern, but certainly confusing to consumers, he noted that the count that the FTC was bringing forward infantilizes the American consumer beyond recognition. And so I'm wondering if there's going to be a little bit of a pullback to sort of the recognition of how how much dark patterns, design manipulation, like plays a role in life. Certainly doesn't appear that he opposes it, strongly supports the first couple counts in that settlement, but definitely worth a read for the COPPA geeks. So for me, one of the most impactful changes that was proposed related to the requirements and oversight of COPPA safe harbors. I was dancing that they were still in there. Cobun, can you share what these are and the new requirements in the rule?
Sure, and I'll try to be quick because I know we're running up on time. Yeah, I mean, COPPA was always really notable in its inclusion of this multi-layered accountability structure in the form of a safe harbor program. It empowers third-party accountability entities to have these safe harbors where companies can go through some form of review process, and the approved safe harbor uh, make can make a determination that they are in compliance with the safe harbor's own rules, which must be consistent with COPPA. Um, this has been the subject of debate on all sides, I guess, for a long time. Some of the safe harbors full disclosure, I used to work for BBB National Programs. I did not work for the COPPA Safe Harbor program for CARU, but through that, I'm a nerd about these sorts of mechanisms. And so this is always a very exciting thing to me as well, to think about what is the right level of uh, what kinds of mechanisms should we require for transparency and accountability and all of these things that you need in this type of thing to make it work effectively. Because part of the goal is always to incentivize companies to join a safe harbor so that it actually has some participation, so that you're bringing more people into compliance with COPPA, and you also have kind of other people checking up on it. But a lot of civil society groups have called for safe harbors to have additional rigor, to have more requirements from the FTC, and some of the safe harbors have actually called for that as well in their guides. This is a big modernization. I think it includes um, some more requirements around independence, and a lot of transparency type things. That's probably the thing I would focus on the most, are the number of of transparency requirements now, including the need to not only kind of report out on your participants every year and publish a list of all of your participants, but also to report to the FTC the specific complaints that you've gotten from individuals and kind of how those have been adjudicated. Um, some of the, I think the critique from safe harbors in their commentary to the FTC before this, there was a lot of concern around getting that balance right of transparency, such that you're not disclosing so much of potential missteps and the process that you've gone through that people won't join safe harbors because they don't want to have all their dirty laundry made available to the FTC. And so this is kind of taking that to the next level for sure. And I don't know. I haven't heard from all of the safe harbors yet, but I'm sure that there's some consternation around how rigorous this is. I'd be interested in the other folks' opinions on the call too, because this has been a long-standing issue of like trying to make it a more rigorous program so that we don't have safe harbors that are really easy to pass, sort of.
Ariel, I know you've done a little bit tangentially here, but certainly heard a lot of the concerns from advocates. Do you have anything you want to add on sort of why this is really important?
I think there can be concerns about, is it the fox guarding the hen house? Concerns about who's making sure there is compliance, and concerns. There have been questions about some safe harbors' effectiveness in evaluating their clients in the past. And so more transparency seems like a positive thing, and also some more requirements. I mean, the unfortunate or fortunate truth is that it's hard for the government to do all of this enforcement and compliance themselves. And so, safe harbors can be incredibly effective in ensuring that people are following the rules or in flagging things to the FTC. But but can't operate with, no oversight on the flip side.
Yeah, I've been particularly geeky about it, considering all the consumer privacy debates about small companies and how do we help them. And in many ways, that's why the Safe Harbor program was created in COPPA, because it doesn't matter how small you are, the law applies to you, it applies. You're an individual YouTuber directed to kids, it applies. So we're just about out of time. We didn't even get to dive into all of the meat in here. I'll say there was a formal definition added of mixed audience, which hopefully clarifies a few things, but I think adds interesting questions about whether the practices of companies who were previously considered mixed audience can immediately begin collecting information when someone arrives on their website pre-age gate. There's some big, interesting compliance stuff there. There's more on biometrics being added, though that shouldn't be new to anyone considering the guidance and such over the past few years. Some stuff on data security. So really, there's so much more we could discuss here. But we are just about out of time. So with that, what's next for COPPA? So I'll say I put into an answer in from one of the Q&As. We've been told that there is 60 days after publication of the rule. So the rule goes into effect 60 days after its publication in the Federal Register. Most entities subject to the rule will have 1 year after publication to comply. My understanding is with the Trump executive order yesterday, and the fact that this was unanimously passed by the FTC, including by the new chair, the rule will probably stand, and it just adds an additional 60 days to that time before it's formally published. But that is very much so a rumor from a news article this morning, so take it with a grain of salt.
I was just looking at it. The president is directing all agencies to consider postponing for 60 days. So I think it's a year plus maybe 60 days from the time that we get it in the Federal Register. And yeah, it does require that, since it hasn't been published in the Federal Register, it needs sign off from the top person. But in this case, like you said, I think we can, I guess, consider that box checked because of what just happened. So yeah, I think you're exactly right.
Absolutely. So what else is next for COPPA? Ariel, do you want to tell us maybe in 30 seconds what you've got?
What's next for COPPA?
Mm-hmm.
I don't know. Yeah, like you said, hopefully the fact that this is 5-0, and I think it looks different than it would if it was 3-2. But hopefully the fact that this is 5-0 means that it will stand. I would anticipate seeing continued enforcement from the FTC of COPPA. And I think it's, anyone's guess what Congress will do with COPPA.
Sara, what do you have to add?
I think same, we may see some action in Congress on COPPA, COPPA 2.0, CIPP, Children's and Teens, whatever we're going to call it once it gets reintroduced. I also think that it'll be interesting to see what Chair Ferguson does with his first month in office, and see if there are any sort of changes that he wishes to make and how things are going to change at the FTC. I know that they have a new commissioner or a new commissioner that's up for consideration. So we'll see what happens with the political makeup of the FTC as well.
All right, final word, Cobun. What's in your crystal ball?
I guess I'll just reiterate, or I'll plus one everything that's been said, including on the Hill. I think one thing we do know is that the new leadership in both the House and the Senate Commerce committees have made it clear that their top privacy priorities this term are to focus again on kids and teens and push forward COSA and COPPA 2.0. But there's also a lot of discussion of resets. But reset definitely on comprehensive, but maybe a reset on the legislative vehicles as well. So lots of ambiguity until we get into the weeds with those committees very soon.
So in the meantime, it's all about this rule. And remember that a lot of things codified in this rule were already on the FTC website. Make sure you go back and check that because those things are already required. With that, thank you so much to my amazing panelists and to all of you for joining. Very, very happy that we were able to have this conversation today and excited to see what else comes in the future. All right. Thank you
Thanks so much,
all
Amelia.
so much.
Yeah.